This is from Jim Hodges. Jim lives down in Florida, and I'm just going to roll the tape. It's 4 minutes, 23 seconds. We're going to stop a couple times and talk about it, but we're going to roll the tape so you can see what's going on. Put some bags of rice on the tripod, but then I would kick the bags of rice, so I don't know that that's going to solve the problem. All right, let's roll the tape. And if you guys can let me know, just confirm if you can hear the video on the video that we're playing. I just want to make sure you guys can see it and hear it.
What's this in your back pocket? I just saw you walking it.
It's a navigational aids. What's the problem? You a tyrant?
Yeah, I am actually. What's your name and date of birth?
I don't have to give that unless
Yes,
I'm
sir.
good.
I was investigating.
You have reasonable.
Do you want?
We're going to pause right there. So we're 21 seconds into this video, and what we see is this gentleman walking down the street. We are watching body camera video from an officer. We later will learn that her name is Deputy Jayme Gohde, or Gohde. She's a deputy here in Florida, this county in Florida. I can't remember the name of the county. It's irrelevant. This could happen to you or me, anywhere. So what's happening is this gentleman is walking down the street. You can see it's daylight out. It appears to be pretty foggy, something like that, but he's walking down the street and he's got this little thing. I don't know if you can see my mouse on the live stream. If you look at his right rear hip pocket, there's this thing in his pocket, and she's stopping him because of this thing in his pocket. So let's continue.
What is your suspicion?
It looks like you're carrying a gun in your back pocket. I'm stopping to make sure you're carrying it properly.
Have you ensured that it's not a firearm?
No, you keep turning so I can't see it. You don't have to be a dick to me.
All right, pardon the language, but now we see what this is. And, you know, this is hindsight on one hand. Maybe give deputies a little bit of benefit of the doubt in some instances that maybe this officer saw this item protruding out of this man's pocket while he's walking down the street. And from what I can tell in Florida, now I'm a Virginia lawyer, so don't quote me on some of this as far as Florida law works. However, from what I can tell, Florida law does not allow open carry of weapons. If you look at this statute right here, I went ahead and pulled some statutes for you guys. The Florida statutes 790.053, it really does seem to prohibit quite a bit of open carry of weapons. And so this officer thinks this guy is carrying some kind of weapon. And to her credit, you can see on the ends there's some silver. It's probably aluminum or something like that. And so it's a collapsible walking stick, but there's some aluminum. She might have saw a glint of metal, this sort of thing in his back pocket, and might have thought this guy's carrying a weapon. But right now, 35 seconds into this video, into this entire encounter, you can tell this is not a weapon. You can tell just by looking at what we can all see with our own eyes that this is a walking stick. And more importantly, you can tell it's white, it's got some red. It looks right away to be a blind person's cane. We've all seen somebody walking down the street or walking in a store with a long, thin cane that they use to find their way around. They use so they don't run into people, they don't trip on things, right? It's a visual navigational aid. And we can all tell that that's what's going on right here. And instead of this officer saying, "Oh, sir, I'm really sorry, I hope you have a nice day," and ending the encounter right now, she doesn't do that. Let's see what happens next.
Well, you're being one to me.
No, sir. I'm doing my job.
Am I detained?
Yeah, you are. What's your name and date of birth?
It does not matter.
Yes, sir, it does.
Do you have crime?
Would you like me?
What's your name?
Sit right here.
All right.
Okay, so unfortunately now, we're 48 seconds in, now we frankly have kind of a piss and match. That's what we would call it in Texas. We have deputy, we have defendant, we have these two people engaging in a pissing match trying to determine, sorry, thanks for the feedback about muting my mic. I was doing that, but then I kept stopping the video too. So it's a little bit hard to juggle everything. Anyhow, so we have this deputy and this defendant engaging in a pissing match, essentially, about what's going on here. He says, "I don't have to identify myself." She says, "Yes, you do." She's threatening to she's threatening to put him in handcuffs if he doesn't comply. And he says, "Well, I want to see your supervisor." And lo and behold, supervisor rolls right up. All right, we're going to try to mute. Hopefully I remember to unmute.
What's she stop you for?
For a walking stick.
And it could look like a weapon. She asked you to really present it, okay?
Now she's asking me for ID.
Okay.
I don't need the ID unless there's reasonable articulated suspicion
that I have committed a crime, am committing a crime, or about to do a crime. Sir.
All right, so essentially this gentleman, Mr. Hodges, knows the law. He's not wrong about what the law says. Let's look at the statute. I'm trying to pull up the right one. Look at Florida's stop and frisk law. So right here we have Florida statute 901.151, the stop and frisk law. And here's this key section. It's section 2. Whenever any law enforcement officer or any encounters any person under the circumstances which reasonably indicate such person has committed, is committing, or is about to commit a violation of the criminal laws, etc., etc., the officer may temporarily detain such person for the purpose of ascertaining the identity of the person temporarily detained and the circumstances, etc. So the law does say that the officer has the right to stop and identify a person who circumstances reasonably indicate that person has committed, is committing, or is about to commit a crime. This is what we would call a Terry stop under Terry versus Ohio, United States Supreme Court decision. This is a Terry stop where we briefly stop someone. We don't have probable cause to arrest them. We have reasonable suspicion. It's a low standard to believe that some kind of funny illegal business is going on. I would argue, if I'm the defense lawyer in this case, that the very moment that this guy has pulled out his walking stick from his back pocket to the first officer, Deputy Goode, once he pulled his walking stick out and said, it's a walking stick, she doesn't have reasonable suspicion. This encounter has become unreasonable from about the 38-second mark, right? It's now become unreasonable. Her initial stopping of him to say, hey, what's that in your pocket? That might have been reasonable. But once she's identified it's not a weapon, her reasonable suspicion has evaporated. It's disappeared. And I would argue the encounter has now become unlawful. But now this is not about trying to protect somebody from, it's not about trying to protect the public from a crime. It's about trying to enforce their authority as the police. They've asked for his ID. He doesn't want to give it. I don't blame him. And he's not giving it, and they're not giving up. They're the people with badges, guns, and handcuffs, and they're not giving up, and unfortunately, it's not going to end well for Mr. Hodges. But you can see as well, the supervisor, he's got sergeant stripes on his chevrons. He's got a sergeant chevron on his shoulder. We can tell he's a supervisor. He's seen now it's a walking stick. He got probably a little closer view of it, but he's still maintaining that Mr. Hodges needs to give his name and information. And I would disagree with that. I think at this point, reasonable suspicion is evaporated. There's no reason to detain this person. And frankly, 20 seconds ago, this stop should have ended with a, I'm sorry for the hassle. I hope you have a nice day. There's no need to continue this. It's crazy. But let's continue and see what happens next.
And her suspicion was that you were armed, okay? And she's asking you for your ID.
Well, now she has verified that I am not armed.
Okay?
So there is no
Do you
problem.
have your ID or not?
I do have my ID, but you don't need it.
Okay? Okay?
So I agree with what Mr. Hodges said. Mr. Hodges explained she verified that I don't have a weapon, and now she doesn't need my ID. And I agree with that. I don't know if the Florida courts would agree with that, unfortunately. That's probably going to be a very state-specific question about what happens, legally speaking, when reasonable suspicion evaporates. Let's continue and see what happens next.
You deserve it.
777. 77 Whiskey Mike detained. I don't know where his wallet is.
Where's your wallet at, sir?
I don't have a wallet on me.
Okay, where's your ID?
Where's your
It's in
ID
my
at?
pocket.
Which pocket?
You are not allowed to search me.
It's in this pocket. Thank you.
Let's pause right here and talk about one thing that Mr. Hodges said. You're not allowed to search me. So yes and no. The issue is going to be if the officers were legally justified in making this arrest, essentially, at this point. They've gone cuffs on. They haven't said that you're under arrest, but I would argue this is way more than a detention. He's certainly in custody for the purposes of Miranda, and I would argue that this is essentially an arrest at this point. And so certainly the police, if they make a lawful arrest, they do have the right to search a person incident to a lawful arrest. This is why if you ever see cops or anything where you see people getting arrested, the police do a full search of the person. They can do a search of the area where the person was, like so they pull you out of your vehicle. They can search your driver area of your vehicle. It's a search incident to arrest. But the whole question in this case is whether or not the entire encounter is lawful once they've identified that the walking stick is not a weapon.
Your names and badge numbers.
1257 on Nick 65427.
Yeah, 4427.
Preferably
Hotel
your cards.
322 457 61 2540.
Yeah, 26, 23, this one.
I'm going to speed up the video just a little bit because there's a little bit of dead time while they're verifying his information.
Sir, are you legally blind?
Yes, I am.
And it's at this point in the video when things start to make sense. I just saw the headline, legally blind man arrested, and I didn't know what to make of it, quite honestly, when I initially saw this video sent to me from a friend. But at this point, the sergeant asks, so you're legally blind? And Mr. Hodges says, yes, I am. Now, I don't know if you've ever had anybody in your life who's got vision impaired. My grandmother was legally blind. She could see quite a bit of things, but she had what we always called tunnel vision, where I guess I imagined it where she had little sort of pinpoints that she could see. So she could see some things, and she could even read, big print at some points. But of course, it got worse as she aged. But legally blind means you do have trouble seeing. That's why we call you blind. Now, legally blind doesn't mean you can't see anything. And so a common observer might see this guy walking down the street with a walking stick and wondering, well, why do you have that walking stick if you're not using it? But it's daylight, and maybe he could see light and could see what he was doing. So let's continue and see what we learn.
I had to walk up here in the dark for jury duty, which was canceled.
Why aren't you using your stick? You don't have to use your stick all the time?
Not all the time.
And now we've learned the answer. So they asked Mr. Hodges, you're legally blind, and he said he had to walk up for jury duty in the dark. And jury duty was canceled. So we have a man out doing his civic duty, trying to show up for jury duty. He got called off for whatever reason that day, and now he's trying to walk home. Again, if you're vision impaired or you know anybody who is, maybe this is now a sidewalk that he's very familiar with. Maybe he walks this block all the time. And so he put his walking stick away. It's daylight out. He can see just fine. But he was using it earlier because it was dark. And maybe he had to go down a street that he wasn't familiar with to get to the courthouse for jury duty. But now they've confirmed he has a very plausible, reasonable explanation of what was going on. And frankly, if they were suspecting him of some kind of foul play, they could probably call the court real quick and said, hey, was he called up for jury duty today? I don't think they do that, right? But they could. They could certainly verify if his story lines up. At this point, though, I think they've gone way afoul of the law and the Fourth Amendment.
26. Green. All right, Mr. Hodges. Was that hard?
It's going to be. I want your name and your badge
You
number.
know, I'll put you in jail for resisting.
Okay. All right, let's go.
I want your name and badge number too, sir.
Have a seat.
You want to pick my property up, please?
I sure will, after you have a seat.
You want to pull this?
So what they're saying is they're going to take him into jail for resisting. So let's look at what the law is for resisting in Florida. When I first heard that, I thought resisting arrest, that doesn't make any sense because he clearly didn't resist their attempt to arrest him. He let them cuff them. He did not provide ID, but he did let them cuff him. But if we look up just what resisting is in Florida, resisting is also known as obstruction in Florida. So Virginia, there's quite a few different statutes. We have obstruction of justice, we have resisting a lawful arrest. In Florida, it seems like it's kind of all rolled into one, and this is what we would call obstruction in Virginia. So 843-.02, resisting an officer without violence, and it says whoever shall resist, obstruct, or otherwise, or oppose any officer, etc., or person legally authorized to execute the process shall be guilty of a misdemeanor. So whoever shall resist, obstruct, or oppose. Did he resist, obstruct, or oppose? Well, he didn't resist, because resist, I would argue that you'd have to look at the Florida cases to see how the courts interpret these terms. Resist probably means to actually pull away, prevent them from cuffing you, something like that. Probably a physical thing. Obstruct, in Virginia, obstruct has been construed to really mean impede, to actually stop the officers from doing their duty. Well, did Mr. Hodges stop the officers from doing their duty? The same thing with opposing, right? Is he opposing them? Well, they did their duty and they verified that he wasn't carrying a weapon. He was carrying a navigational aid, as he put it, a walking stick, because he's blind. So I would argue that he's not obstructing or opposing, and he's certainly not resisting. But what do they need to arrest somebody, especially for a misdemeanor? This is a misdemeanor allegedly committed in their presence. I don't know Florida statutes specifically on this matter, but in Virginia, the police can arrest you for a misdemeanor that allegedly is committed in their presence as long as they simply have probable cause that you did it, you're the guy, and if they saw it in their presence. So in this case, I could see Virginia cops doing the same thing, saying, oh, they're taking this guy in for obstruction, and resisting is a similar thing in Florida. It's crazy. I think that's, here, we'll continue with this little last bit of the video and then we'll talk about some conclusions.
Out of my back pocket.
Sure. Here, I'll grab your jacket for you too.
So remember how this video started. This video started with this officer suspecting that Mr. Hodges was carrying a weapon. Remember, the very beginning, she thought it was a weapon in his pocket. Now, they've confirmed for sure it's not a weapon because they've got the guy in cuffs, in custody. He's under arrest for resisting. They're taking him into custody, putting him in her cruiser, and they don't even take the weapon from him. And frankly, even though it's not a weapon, he's under arrest, and he says he doesn't need his walking stick right now. They should have taken it simply for his safety and theirs, right? It's certainly something that he might could hurt himself with or make some kind of problem in the squad car. It's almost ludicrous at this point that the original reason they stopped this guy in the first place was because of this weapon. They clearly know it's not a weapon, but it really is something that should have been taken out of his pocket now that he's in custody. It just doesn't make any sense. And really this shows what I said earlier, this is a pissing match. As some people are pointing out in the comments, no, they definitely did not pat him down. They didn't search him. They didn't check his pockets. They did search, I guess, for his ID. So maybe they would say that, while searching for the ID, they didn't find any contraband or anything. But I don't remember them actually checking his waistband or anything like that. I'm not going to go back and roll that, but it's crazy. It's just really crazy. Let's see. So we have a couple other things to look at here. One, if I can get it onto the screen here. Here's the other thing we want to talk about is the Columbia County Sheriff's Office has released a statement on this issue. I'm going to try to zoom in. We are aware of the Columbia County Sheriff's Office body camera video involving the arrest of Mr. James Hodges. Sheriff Hunter is troubled by what he has seen in the video, and the matter is being addressed. An administrative investigation was initiated on November 3rd when the incident was brought to our attention. If policy violations are sustained at the conclusion of that investigation, appropriate action will be taken. While we understand the frustration and concern associated with this event, please know we are working to resolve this matter as quickly as possible. So the sheriff wants you to know that they're checking for policy violations. As a person who has personally observed police abusing their authority and has personally reported that abuse up the chain of command to prosecutors' offices and every which way, and personally seen it just neglected and just dismissed as, oh, it was just a joke, or it's just a misunderstanding, I have zero faith that Sheriff Hunter is going to come to the right conclusion. And here is Sheriff Hunter, just FYI. So Sheriff Hunter is the sheriff in Columbia County in Florida, and he's the guy, his department's going to investigate one of their own to see if there's a violation of their policy. To me, the violation of the policy is the Fifth Amendment, or the Fourth Amendment. Sorry, I'm getting upset. The Fourth Amendment was violated, I think, in this case. I think this was maybe started at the very beginning as a legit encounter, a legit concern from the deputy. But as soon as the pissing match began, she had to win. And she had to win by taking this man into custody. And frankly, whether or not there's a policy violation, somebody needs to be in trouble for that. This should never have happened. He should never have been taken into custody. He should have been released. Shouldn't have even been cuffed. They should have said, "I'm sorry, sir, didn't realize that was a walking stick. Have a nice day." That's the way it should have ended. The one comment I'll add for Mr. Hodges, I hope you're doing well and I hope you get through this. And frankly, there may be a settlement as some people have talked about in the comments. The biggest thing I will point out is that if you're ever in this kind of situation, think about how your behavior might play to a jury. Mr. Hodges did a pretty good job, but I think you could do better. I think you could, watch your language just a little bit and try to be even more sympathetic, frankly. You could, frankly, just not even talk. The first rule of Felicia Freedom Club is don't talk to the police. I say that in almost every video I make because talking to the police gets you in trouble. How much better would it have looked if Mr. Hodges had simply said nothing to the police? They said, "What is that in your pocket?" He pulled it out, held it up, and then they arrested him. I think it looked even better for him, frankly. And how would that play to a jury? I think not talking to the police is almost always your best bet, especially when it's clear that they're hassling you, they're suspecting you of something. Don't talk to the police. It's always your best bet. So let's engage with the comments a little bit. I don't know if you can see this. Gary Webb says we have freedom of speech for a reason. Well, yes, Gary. Actually, hang on. I think I gotta move this over. Maybe you can see it now. Gary Webb says we have freedom of speech for a reason. I agree with that. Yes, it's very true. The government cannot stop you from speaking. But you also have prudence and a brain for a reason, and you have the Fifth Amendment for a reason. And you need to use all those things. If the person with the badge and the gun and the handcuffs and the squad car is hassling you, it's a good time to keep your mouth shut. Okay? Good time to keep your mouth shut. This is another good, whoops, it did pop up. There we go, I got a comment to pop up. All right, Tim Behringer says, maybe I missed it, but I did not hear Miranda read. Now I'm going to remove it because it's covering my pretty face. Basically, Miranda is only required for what's called a custodial interrogation. Okay? In this case, it's very clear that the police are not interrogating Mr. Hodges. They don't suspect him of committing a crime. They suspect him of committing the crime only of not cooperating with the police. Okay? That's what Mr. Hodges did, is he didn't cooperate and do what they wanted him to do. And so they're not asking him, like, where were you on the night of October 31st? Who were you with? What's your alibi? You know, that kind of interrogation is where Miranda really comes into play. In most police arrests, Miranda is not an issue because usually they get whatever evidence they need, then they arrest you, and then it's a done deal at that point. So Miranda is not usually an issue that comes into a lot of cases, quite honestly. Let's see. I'm trying to get this comment. Okay. Fitness On says, would it be better for him to point out the mistakes they are making on the spot? No. One of the reasons this whole thing went south, and I'm not trying to criticize Mr. Hodges. I appreciate his situation. I appreciate that he was going to jury duty and walking there. Good on him. I'm not trying to criticize him at all, so don't misunderstand me. But when the police are all about controlling a situation, exercising command authority over a situation, and if the suspect, who they're supposed to be controlling, is pushing back right in the moment, that's when you have the pissing match where both sides are trying to up the ante. The guy with the gun and the badge and the handcuffs is going to win. Now, you may win on the back end, right? You may be able to sue or something, but you're the one who is going to go to jail, not the guy with the handcuffs. So if you want to stay out of jail, the best answer is to not talk to the police and not point out all their errors. Make mental note. If you can, film something like that. Tell a friend, hey, pull out your camera, film what's happening. That's fine. But to be pointing out their errors and telling them how they're wrong on the law, that's probably a good way to land yourself in jail. Okay? Okay, here's a comment from Warren D. I don't believe those cops would have let him go if he was totally silent. I think the comment continues, I think it just makes the cops more angry. And that may be the case. You know, this is Monday morning quarterbacking or Tuesday afternoon quarterbacking, you know, in my time zone. But yeah, so it may not have worked. But the other thing, like I said, is think about how this is going to play to a jury. If you do end up having to sue, right? If you look meek and mild and humble, and these mean cops are hassling you and harassing you and putting you in handcuffs, it looks even better for a jury someday. And here's, Pinay Machine says, wouldn't pointing out their mistakes on the spot potentially prevent them from bringing you to jail? Maybe, but not likely. If an officer has got in their mind that you're in the wrong, you're not going to convince them that you're right. I don't think that's the right approach ever, to point out officers' mistake on the side of the road. Like I said, make mental note, make notes as soon as you get home for your lawyer or to represent yourself if that's what you want to do, but I would not point out the mistakes on the side, on the side of the road. So I don't understand what it is with people thinking that you can't just be silent. So Jay Morgan says, I agree, if you're silent could backfire, especially if it isn't being recorded. Well, so, okay, let's talk about this. What do you think is going to happen if you're actually arrested for something, like DUI is what I commonly deal with in my practice. But if you're arrested and the police later have to come to court and testify, what's going to happen is they're going to testify to everything they said and everything you said. Isn't it better if the police do what they think they want to do anyway, and then all they can do is they can testify to what you did, what they saw, and what they said, right? You're not going to continue to dig a hole. You're not going to continue to add fire to their anger or whatever it is that they're expressing against you by talking to them. It's just a really bad idea to keep talking and trying to dig out of this hole that you're in. Now, there could be limited exceptions where it might make sense to talk to the police, but it's very rare, and the best rule of thumb is don't talk. Now, keep in mind, I'm not saying to be a jerk, and that's what I was telling earlier about Mr. Hodges' conduct. He did a great job overall, but watch your language. Don't be a jerk, okay? That's never going to help you, obviously. All right, let's see. Yes, Cycle Boy says, test a lie. And the problem with testimony is the memory is malleable. The memory is fungible. The memory changes over time. And even if an officer, I mean, I know some good officers who frankly I don't think would ever lie, but it's hard to remember everything. And if you arrest, dozens of people for DUI, all those cases start to meld together, right? And then that's where you have the rote, repetitive testimony as I saw bloodshot, glassy eyes, slurred speech, and he was unsteady on his feet. They say that thing in every DUI case. And frankly, it's remarkable when they don't say it, just because it's crazy. All right, Action Com asks, where is the line between remaining silent and dispelling concerns by the police? The line is called the handcuffs. No, I'm kidding. I guess it all depends upon what's going on. The rule of thumb that you should always, your instinct, the first thing you should think if the police are there is to stay silent. Keep silent, keep silent, keep silent. And that's one reason I say don't talk to the police all the time. Because that's the rule of thumb. That should be your default position, right? It's like a switch. The default switch is off, right? You're going to keep your mouth shut. Then, if there's something going on where it could be only helpful to say something to the police, you can make that judgment call that maybe it's okay to talk or to answer that one question, But then you got to really think about that carefully. The best example I have is I was rear-ended while I was driving. It's been years ago, but I truly remember to this day. I remember sitting there on the side of the road. We all pulled over. It was several cars got rear-ended. And I thought about it. Am I going to talk to the police or not when they get here? They were on the way, and I was thinking, did I do anything wrong? Is there any way they can construe any of this against me? And after I thought about it, I had several minutes to think about it, and I thought, no, there's no way I did anything wrong. I was stopped. I got rear-ended, and so I'm going to tell the police that because I knew that my words weren't going to hurt me. But I'm also a traffic lawyer. This is what I do every day, And so I feel like I was in at least a pretty good position to determine that it was safe to talk in that situation. But it's not always safe, and you got to be very careful if you do talk to the police. Cheerful Mouse, thank you. Your energy makes these topics easy to listen to. Thank you. I'm glad you think I have energy. I had some espresso before I went live. Okay, Daniel Higuera says, in some states, you're required to explicitly tell the cops that you invoke your right to remain silent. Otherwise, they will accuse you of stuff like this obstruction BS, is where the comment continues. Okay, the Supreme Court, there's some Supreme Court cases on what does it take to invoke your right to remain silent. It's really complicated body of law, actually. But essentially, if you're talking to the police and answering questions and everything and cooperating, and then all of a sudden they ask you a question and you just don't talk. There's a case, I can't remember the name, but there's a case where the Supreme Court has said that the police can testify about your silence. They can say, well, we were interviewing Mr. Flushy and we were asking him about XYZ and he answered all these questions. And then when we asked him where he was on the night of November 1st, he wouldn't answer that question. And so that can make you look guilty, right? Because if you're cooperative and chatty and then all of a sudden you clam up. And the court basically said that that was not an invocation of the Fifth Amendment because he was talking and then he didn't actually invoke the Fifth Amendment. And so all they have is silence. So there's, in a way, yes, in a way, the best thing, especially if there's something serious going on, is instead of just being quiet, you should maybe at the beginning say, I plead the Fifth or I invoke the Fifth, and then shut up. Literally, just keep your mouth shut. It's that simple. And I know it's easy for me to say, but be quiet. Samuel Black says, fellow Texan makes it better too. Awesome. We appreciate it. I'm now kind of claimed by Virginia. We've been here a long time. And so Virginia is certainly home, but Texas will always have a place, and I'll always consider myself a Texan at heart. Okay, so this is back to what I was talking about a second ago. Eno says you have to let them know you're invoking your Fifth. If you don't, it won't hold up to be silent. In a way, that's true. Like I was saying, there's a Supreme Court case that essentially, that's where that idea comes from. But lost my train of thought from another comment. Sorry, this is hard to do. But what the point is, if you don't answer their questions, you're not incriminating yourself, right? So again, I always come back to DUI because this is what I do every single day. So if they're asking you, where did you drive from? When was your last drink, right? And if maybe you didn't invoke your right to remain silent, so they can tell the judge, he wouldn't answer my questions. Okay, well, the judge still doesn't know that you were coming from a bar and you just downed 6 shots of whatever, right? It helped you to remain silent. It always helps to remain silent. Let's see, here was a great question. Warren says, does Virginia still fine you for radar detectors? Yes, indeed. If you ever drive through Virginia, you'll see big signs when you come into our state, radar detectors, illegal. You can't have it anywhere accessible to power, essentially. So if you have one, you come here, you need to pull over right away, throw it in the trunk. That way there's no claim that you have a radar detector running. ActionCom asks, is it okay to ask questions if they have their cameras on, just to get them on the record? No, don't talk. Right? Don't talk. It's not a good plan. Aha, here's a great. All right. RallyX0 says, you give great advice for surviving the policing system, but what about fixing them? Elections matter. Today, November 8th, happens to be a federal election day. And I'm not going to put on my little, I should have worn my I voted sticker. I didn't get one today because I don't like stickers. But elections matter. Sheriff Hunter in Columbia County, Florida, he was elected, right? He's the guy in charge of doing whatever is going to happen to these officers. Elections matter. Who you vote for matters. And so you need to get out and vote. I'm not going to turn this into a political ad, but if you like freedom and if you like people being out of your business, there's a party that stands for freedom, and that's the party that I would recommend you go vote for today. All right, cool. Oh, this is interesting. I was going to check for an update on this case, and I should have, but I just got focused on getting all the technology to work. This update from 4Cats Now. I love cats too. We have 2. Local news outlet Lake City Reporter indicating charges dropped, which is good. Good for Mr. Hodges that the charges were dropped. I'm sure the public pressure certainly helped get the charges dropped. Okay, Paleo Khan says, is there some fine print where I sign away certain rights at checkpoints? I guess the question is, what kind of checkpoints are we talking about? If you're talking about border checkpoints, like for coming in and out of the country, it's very specific, big body of law, okay? Very specific. And so it's hard for me to say what's happening there because I live in Virginia where we don't have a border, right, where we have these issues. It's something I want to research, frankly, because we have quite a bit of questions on the channel about that. And so I definitely want to work on a video about like our national borders and what you have to do. But as far as if you're talking about DUI checkpoints, it's simply the Virginia Supreme Court eroding the Fourth Amendment. Or not Virginia, the United States Supreme Court continually eroding the Fourth Amendment. It's a shame. You don't sign away your rights. The police can stop you, but they cannot make you do tests at a DUI checkpoint. Okay, they can't make you do tests. Let's see, there was a good comment here that I wanted to talk about. This is actually a good question. Psychic Walnut says, would there be a downside if I just sat down before getting handcuffed and not assist in his movement to the cop car? Yes. Essentially, sitting down wouldn't be a problem. But then if they're trying to cuff you and arrest you and put you in the cruiser and you're physically like going limp or something like that, right, then they probably would have a much better argument that you were resisting the arrest or trying to impede their ability to do their job. So I don't recommend that. What can be a good, frankly, I know a deputy friend of mine who says that if he was ever accused of a DUI, he would sit down on the curb, put his hands behind his back, close his mouth, and shut his eyes. And there's something to be said for that. And they can't say that your eyes are bloodshot and glassy. They can't say they smell the odor of alcohol. They can't say you're unsteady on your feet. You get your hands behind your back so they can cuff you, right? So it's an interesting approach. There was a radar detector question. Yes. Warren Diaz, does Virginia have a way to detect your radar detector? Yes. I learned about this a little while ago, a couple of years ago now. A state trooper friend of mine has a radar detector in his cruiser. And so essentially, I'm not an engineer or a scientist, but essentially there's a way that there's a device in his cruiser that can detect if you have a radar detector running in your car. So they can get you. I don't think all of them have it, but you can get it. Well, okay, so we have a follow-up on the checkpoint thing. Where did it go? Okay, Paleo Khan says, stopped the DUI checkpoint last month. The sergeant said something to the effect, I signed away my right to not present my ID at checkpoints. Is that correct? Yes. Most states have, we saw Florida's stop and frisk statute we looked at earlier if you were here on the live stream. And basically most states have something that says if you're driving a motor vehicle and you're lawfully stopped by the police, you have to present your license and registration, is what Virginia says. Yours is probably different depending on your state. And so a DUI checkpoint or license checkpoint is considered in most states a lawful stop. So if the police make a lawful stop, they can ask for your ID and you got to present it. Now, if they end up finding some kind of crime or something and charging you with something, then you can go back and challenge the checkpoint. And it can be hard for them to prove that the checkpoint was actually valid to begin with. Okay, but that's definitely something you definitely should provide ID at checkpoint. Let's say. This is a great question. I need to work on my comments showing the full text, so sorry that these are getting clipped off. But Alden Patton says, if you're charged with a secondary charge like resisting or failure to identify and the primary charge is dropped, does the secondary charge automatically get dropped? No, unfortunately no. It's not automatic, but the question will become, why did the primary charge get dropped? So for example, let's say you get... So let's say you get accused of, jaywalking. That's just something we didn't talk about in this case. Is Jim Hodges, there's a report that I saw where the officer initially claimed in a report or on a news story that she actually saw him essentially jaywalking, walking when the signal said don't walk, right? And that was what drew her attention to him in the first place. Under Florida law, that's actually a traffic infraction to be either a traffic, a vehicle who doesn't obey the crosswalks and doesn't yield, or if you're a pedestrian and not obeying the crosswalk sign, it's actually jaywalking, which we all know about. Most people don't enforce that statute. But anyway, the Florida officer could have ticketed Mr. Hodges probably for jaywalking. And frankly, I'm not quite sure why she didn't do that. That would have been a way to exert her dominance, just to give him a ticket for jaywalking and say I was going to give you a warning for that. But anyway, but let's say she did ticket him for jaywalking and arrested him for obstruction or resisting or whatever because he wouldn't give his ID at first. Just because he beats the jaywalking ticket doesn't mean that the obstruction goes away and vice versa. But let's say the police stop you for something and they end up having a bad stop to begin with. Right? They stop you for, let's say they claim that you swerved and they end up finding a DUI, right? Thinking you're drunk. But if the stop is bad to begin with, then everything that flows from the stop would be suppressed. That's typically what happens in a Fourth Amendment violation is basically everything is fruit of the poisonous tree. And so everything that flows from the bad thing gets suppressed, and so the initial encounter really matters. So it depends on why the primary charge was dropped. It's a good question, Victor. How often do people get arrested for jaywalking? We are kind of a culture of jaywalking, as I pretty much see it. Everyone do it. It's a good question. I don't think pretty much anybody gets ticketed or arrested for jaywalking, but it is on the books, and so that would have been a valid reason for the deputy in James Hodges' case to ticket him. It appears that from what I saw in a news story, it appears he allegedly was jaywalking. Now, she didn't say that on the body camera, but that's what allegedly happened. Let's see. That's a great question. What happens if you are a Maryland driver pulled over in Virginia? Do all the implied consent laws still take effect? Yes. It's kind of crazy. The concept of implied consent is by getting your driver's license here, you impliedly consented to having your breath sample taken. Well, really not the case, because implied consent applies to everyone who drives on the highways of whichever state we're talking about. And so just because you didn't get your license here in Virginia, for example, doesn't mean implied consent doesn't apply to you. So it's really kind of a misnomer, in my opinion. Implied consent it's kind of a misnomer. It's really just the state's making you consent. The state's making you do this. You never actually consented, but we're going to make you do it. All right, so we have a good question here from a super chat. We appreciate the super chats. If a state like New York, which does not have a stop and identify, can you get in trouble for using to hand over ID? Like no probable cause, thanks. Identity laws are very complicated. It's one reason I don't talk about them a lot on this channel, because it varies a lot based on the state and based on the county even that you're in. There's all sorts of laws on identify laws. So it's really hard to give any kind of general pointers about identify laws. Really the best thing is to learn your local law. Learn the law in the county and the state where you live and where you primarily are. And that's how you'll know how to handle identify laws. I wish I could give you a better answer, but it's just very, very state specific and even county specific. I missed another super chat question here from Two Dog Night. Can you call your attorney to answer a question? Excuse me. Losing my voice here. We've been going a while. I guess you're meaning on the side of the road. Can you call your attorney if you're there on the side of the road? The answer would be no. Most officers are going to say no. You can't, basically you don't have any right to call an attorney while you're being investigated. Okay? And so, no. This is a great response here, Norhawk. Just to kind of change the subject, he says, for Fury, there is no quota, but you do get looked at as a poor officer if you have no arrests. This echoes what I've seen in my practice. I've been doing this for a long time. It's hard to even remember, 14 years now. And what I've learned, I've never seen anything that made me think there's actually a quota, where there's actually a department saying, at least around where I practice in Virginia, where there's a department saying, you've got to have 100 tickets this month, and if you only have 99, you're fired. I've never seen anything like that. However, there's an understanding, which is a little different than a quota. There's an understanding that if you're going to have a uniform and a car and all this equipment, and you're going to be on duty however many hours or days a month, that you need to be having some police contact, some citizen contact. And if you're not doing anything with that citizen contact, what are you doing with your time? Basically, there's an understanding that there are violators out there, there are people speeding, et cetera, and if you're not doing anything, there's a problem. So I don't think there's a quota. I think there is comparison, sort of comparative statistics among officers. And there's certainly, video I'm going to do at some point, there's certainly awards based on how many people you arrest. So it's not necessarily a punishment for not arresting enough people, but for example, the MAD awards essentially award a prize to the officers who make the most DUI arrests. Well, that's not a quota, but it certainly is an award for arresting people, which seems to be a conflict of interest. I think we're about to call it. This is a good question, though. Could you stop a motorcycle before a checkpoint and walk it around so you're not driving? It's a good question. There are a whole body of cases that deal with people who are evading a checkpoint, right? I've had plenty of clients who, they have a checkpoint set up, you can see, and a person makes a turn right before the checkpoint so they can go a different way. This is exactly what the police would claim is you were trying to evade the checkpoint. Arguably, you could do that, but I think you would still be going through the checkpoint, right? And I think the police would still have a good articulable reason to ask, why are you just walking your bike through here? I still think you'd have to identify yourself if you went through the checkpoint, but you can certainly turn around. And there's there's a whole body of cases about whether or not the police can pull you over if they see you turning around instead of going through the checkpoint. So I think if you were walking your bike through the checkpoint, it would be similar where the police could say you were trying to evade the checkpoint and therefore we can identify you. That's kind of the deal. I think that's about it. I'm running out of voice, and I really appreciate everybody showing up. We're going to try to do a few more live streams. I hope the technology works better, and I'm going to try to work on my comments displaying better. Please subscribe to the channel. It really helps us out, and I really appreciate everybody being here. It really means a lot to me. And remember what I said earlier, go vote. If you're not registered to vote, I'm sorry, maybe your state would allow you to register today. You can check that online, and you should go vote. The polls are open. Right now it's about 3 p.m. Eastern, so our polls are open till 7 o'clock, I think. Depending on where you are, there's probably still time to vote. Get yourself to vote. Voting matters. Elections matter, especially local offices, especially representatives. All the representatives in the country are on the ballot today. Everybody's has a congressional vote that you can make today to change Congress for the better. So vote. All right. Thanks for showing up, and I hope you'll have